Kia ora no tātou. Sir, I'm going to focus on part 2, and as you would expect, and I want to assure you I shall do so in a manner that does not offend either your rulings or the person who was in the seat that you currently occupy until very recently. However, sir, I want to take us initially to part 2, page 30, section 26. And so there's an interesting irony here, because what we're being invited to contemplate as, and I do find it difficult to actually follow in a kind of an administrative sense how it's to take place. However, we will have, by dint of the passage of this legislation, a situation where Crown and subnational bodies of government will now have their assets regarded as part, with certain exceptions, as part of the great public space, etc. But there will, sir, be an opportunity for local government to seek redress. And I think, sir, this is one of the reasons why a number of hapu and tangata whenua have probably been stirred up. And the minister may say ill-informed, although I would say they probably see a double standard here. Now, sir, a number of them will point out to us that the original way in which local government and other public bodies acquired either the land for the roads or other interests in land adjoining the seabed and foreshore, the Takutai Moana, should I say, and those original grievances haven't been satisfactorily dealt with. And they're going to complain, as they already have to us, that there's a very circuitous process that they're expected to go through, but there seems to be a very straightforward process for the local body organisations to go through. And I think it's one of these. It's a case where probably a well-intentioned intervention has turned into an issue as to whether or not there's a double standard here. Now, I do note, sir, that the Minister of Conservation, or his or her delegate, I think that's the term that's being used, delegate, will have and presumably speak with the authority of the Crown. But, sir, no court, and if I'm not mistaken, I think this is carried over, and the Minister might care to confirm this from our piece of legislation, no court will be entitled or enjoy jurisdiction to hear any claim in respect of the loss suffered by the local authority as a result of the operation. Now, if that is, sir, partly that part of what was carried over from our bill, then it could be one of the few redeeming features in the current bill, but that's another matter. But I do think, sir, that as the Minister goes forward, issues of this nature are going to have to be carefully explained to Māori applicants, because if there's a case where there has been a great deal of pain and confusion, it is in the area of local government. So I just want to go back and also direct our attention to section 11, because my colleague David Parker has pointed out that, yes, the nomenclature is different, but when you unpick what are the interests at stake in the new takiwā marea, my brief attempt at translating public space, the Crown has exclusive authority, number one, in the allocation of entitlement to occupy space. The Crown will have exclusive authority to set conditions to manage the effects of interaction, activity, use, etc. in the space. The Crown will have enormous, if not exclusive, authority in enjoying the ability to exclude. Now, I accept, sir, the Minister may say, well, once a title or a customary interest has been recognised, there will be a certain level of ability within the hapu or the tangata whenua group to exercise enough authority to ensure that what interests they're having restored to them, they can exclude others from having an injurious effect on their interests. Now, sir, it makes in my view, a nonsense, Mr. Chair.
Shane Jones.
Sir, it makes, in my view, a nonsense to suggest that what we've replaced here in terms of Crown title with this broad, vacant kind of conception of the space championed by Peter Dunn, appropriately so, that somehow, sir, that this is both a novel and something significantly different from the Crown. I accept that it does overcome one issue, and that is that the Crown, in the politics of polarisation, is often seen as the wrong side of the equation. But I do want, sir, and I'd invite the Minister during the course of the evening, all of tomorrow, and more than likely early next week, to take a call and correct either myself or David Parker as to whether or not we are perhaps being a little too uncharitable or misunderstanding the actual impact and effect of the law in relation to the way in which we're describing it, sir. So I want to go on and point out that in section 30, the Minister of Conservation is the manager of the common marine coastal exercises and performs in respect of all the coastal area, all those management, admin, duties, functions provided by this Act or any other enactment, which only goes to show, sir, that nothing in this bill significantly changes in terms of the Crown having that exclusive level of authority. And therein lies, sir, I mean, it's politics, but at one level it's a symbolic fiction which has been promoted by our colleagues in the Māori Party. But they're entitled to do that, and it really depends on how well that message is picked up amongst our people or by our people, because they have assumed that our people don't have the sophistication to see that they're being hoodwinked. And I think, sir, therein lies one of the sad things about this bill. They deeply know that Hone Harawira's concerns are largely accurate, but they've taken a punt that iwi and hapu are either tired of the whole affair, or they can assume that they won't get access to advice or they won't put the effort in to uncover the fact that this, sir, is really an exercise in chicanery. This does not deliver the promise, this does not deliver the things that they put in their manifesto. But, sir, unfortunately for us, we are incapable of stopping this piece of legislation, other than the fact we will remind our people how it has, yes, it has not been possible for them to enjoy the success they thought they were going to get through the Māori Party. Sir, now, I want to take our just direct the Minister's attention to section 39, determination of application by Minister. Now, sir, it's kind of extraordinary, and I should imagine there's some strong commercial applications here, but we are putting Māori applicants through an inordinately circuitous process in order to prove their interests. But, sir, in this section, and in a section slightly earlier dealing, sir, with the ability of developers to acquire a level of interest in the land that's not being extended to hapu and iwi, not being extended to tangata whenua, and indeed, sir, I'd direct our attention to section 39, subsection 1, paragraph 8. And so what does it say there? Where the applicant is to be granted an interest in the reclaimed land, and if so, whether that interest should be a freehold interest. So, sir, that is not what Labour agreed to, and I'm quite sure that the Minister will agree. And the first time round, this is not what we agreed to. So we preferred a leasehold interest. Now, it could be said a very long-term lease is akin to a freehold interest anyhow, but it's rather bizarre that the legislation which is being promoted by Tariana Turia and her team as having actually expanded the prospects of Māori securing greater customary interests is actually going to provide developers and the private sector with something akin to an alienable title. But they're unwilling through this legislation to extend it to their own supporters or to iwi Māori. Now, sir, it's just a small example of how, number one, they've been inattentive. They've surrendered a great deal of control and stewardship, dare I say, the sovereignty of the pen to the Attorney-General. And in many respects, that's necessary. because he is the most senior legal official in terms of Cabinet's makeup, but don't for a moment think that the irony will not escape, sir, Māori voters, or do I say Māori applicants, that somehow or another they've got to go uphill, down dale, across the sea, the Takutai Moana, through a very circuitous range of steps, and at the same time, this piece of legislation, crazily enough, actually makes it arguably easier for large-scale commercial interests to secure a greater level of ownership on reclaimed land. Now, so the Minister may say, well, as the land has been reclaimed, someone else had already lost out prior to that because it was presumably, if not vacant, dormant space, Mr. Chair.
Chair.